people. So we are doing model papers. In this video, I'll be doing, the 3 model papers, that is series number 8, 9 and 10. And don't worry, by the time I'll be uploading this video, I'll be also giving you a merged version of 1 to 10 model test papers. All that you guys need to do is just sit back, relax, see as many questions as possible, and remember, the main key is to identify the provision in law. So if you guys get that, then you guys get everything. Yes, it's okay. Writing section number is secondary. Writing case law is secondary. The main prominent and primary important thing is identifying the provision. If you guys get the provision right, and yes, you guys will nail the attempt. So your main focus is to identify the provision. And that is what we are trying to do in this particular video. Let us try to identify the provision as much as possible. And you guys also try to pause the question from your end. I know you guys have read sufficient. So along with that, just try to solve it. Yeah. Try to identify the provision and try to write down keywords somewhere there. If that is there, you guys will get the marks. Yeah. So let us start. Okay. Mr. A was running an orphanage. His friend Mr. S, a philanthropist, agreed to donate 2 lakh for treatment of a child who was suffering from cancer. On emergency, Mr. A incurred 1.5 lakh on treatment of child. Now Mr. S refused to pay the money. Whether Mr. A can claim 1.5 lakh from Mr. S with reference to the provision of Indian Contract Act 1872, decide. Now what is the answer, people? You tell me. Does it form a valid part of contract? The provision you'll be writing here is, people, this forms part of consideration and it comes under exceptions to quid pro quo. That is, give and take will not be there, and this is charity. Now see, charity is the main provision. In my question, I'll be underlining the word called charity. That will be my provision. So what do you mean by that? My opening statement will be, a contract will be invalid if there is no quid pro quo in the contract. So a consideration should always be bilateral. Give and take should be there. That's my provision. However, this rule has certain exceptions. Because it's a 3-mark question, I need not write all the exception. The only exception I'll write is, people, charity. So under the charity, when will the charity become a binding contract? That is in quid pro quo. When will charity become a binding contract? In quid pro quo, charity will become a binding contract. One more thing, one more keyword that you guys have to write in the provision is that, people, a charity becomes a binding contract when the party has undertaken a liability. In the given case, they have undertaken a liability, they have taken up the treatment. Now it becomes a binding contract, and hence, yes, Mr. Yes will be liable to pay whatever is the money that he has promised to pay. Is this clear? Hello? So yes, I can claim that 1.5 lakh rupees. Is this clear, all of you? Okay, done. Next one. Mr. L let out his residential house to Mr. M for 50,000 rupees per month for a period of 1 year. According to the rent agreement, electricity bill will be paid by Mr. L. But Mr. L could not pay the electricity dues up to 5 months due to his financial hardship. The electricity board sent the notice of disconnection if it is not paid within a week's time. To avoid all this, Mr. M paid the electricity bill of 50,000 with penalty. Later on, L refused to reimburse 50,000 and argued that he has paid the bill voluntarily because of his own interest. Decide with reference to the provision of Indian Contract Act whether Mr. M is entitled to be reimbursed by Mr. L. People, one very main important thing I always tell in the classes that, people, whenever remember, if at all in the question, the main question we always have will have is, sir, how do we identify which provision does this question belong to? Now, how do I identify that? It is very easy, people. In the question, there will be clues. The keywords in the provision will be there in the question only. For example, see here, because of his own interest, that's the keyword. Now, in which provision does this main word come? His own interest. Yes, people, this is a case of quasi contract. That is my provision. It is not a contract in itself, but it resembles a contract. Now, in quasi contract, what is the word I'll be searching here? Which is a provision? The provision is, people, payments made by a interested person. Agreed? Yes, sir. So, people, if at all the electricity bill is not paid, they are going to take away the fuse. Even I am also going to suffer some loss. Because of that, because to protect my interest also, I paid this money. Now, in this case, people, remember, I can recover the money from the owner because I made the payment to protect my own interest. Because even I have some interest in this property. If I don't pay, this interest will go. So remember, people, I can recover. Okay, next one. I hope it is clear. So in this case, can I recover? Yes, Mr. M is liable to reimburse the money to Mr. L. See, my only focus is on provision and the keywords. That is more important. If you guys nail the provision and keywords, trust me, people, no one can stop you from getting 60 to 70. No one can stop you. Clear? XYZ Limited was incorporated to hold the patent for a new product. The company is expecting to start its commercial production within next 2 years. In the meanwhile, for timely installation, the company has placed the purchase order for plant and machinery with a down payment of rupees 1 crore. Referring to the provision of Companies Act, examine whether the company can go for acquiring the status of dormant company. Section 455 of Companies Act 2013 says what, people? What is a dormant company? A company which is formed for a future purpose, future project. A company which is formed to hold any of the intellectual properties or any asset, provided the company should not have any significant accounting transaction. Yes, people, here they are formed for a future object, agreed. For next 2 years, they will not have any production, that also agreed. But remember, people, just now they have spent 1 crore rupees, which is a significant accounting transaction. Because what is not a significant accounting transaction? Any money paid to the registrar, any money paid to fulfill the obligation of this act or any other act, like payment made to a CA, payment made to authorities, that is not considered as significant accounting transaction. The third one is share allotments. The fourth one is maintenance of office and records, like rent. That is not considered as significant accounting transaction. Anything else is a significant accounting transaction. Hence, this company cannot obtain the status of dormant status because they have done a significant accounting transaction. I hope this is clear. Clear? Done. Next one, Mike LLC incorporated in Singapore, having office in Pune in India. Analyze whether Mike LLC would be called as a foreign company as per the provision of Companies Act 2013 and explain the meaning of foreign company. A company which is incorporated outside India and having a place of business in India will be considered as what, people? Will be considered as a foreign company. What do you mean by foreign company? A company which is incorporated outside India, which has a place of business in India and carries on business activity in India. In our case, let us assume it is carrying on business activity in India. Satisfying these three grounds, it can be considered as a foreign company. Okay. Direct question, I'll not take it up. Sony, a friend of Priya, wanted to buy her two-wheeler. Priya agreed to sell her two-wheeler to Sony, and it was decided that the price of her two-wheeler will be fixed by Priya's father, who is an auto dealer. Priya immediately handed over the keys to Sony. However, Priya's father refused to fix the price as he did not want Priya to sell her vehicle. Priya expressed her inability to sell the two-wheeler to Sony and asked her to return, but Sony refused to return the same. Explain, can Priya take back the vehicle from Sony? Will your answer be different if Priya had not handed over the vehicle to Sony? Remember people, we have already seen this in the previous thing. People, I'm doing the 8th one now. 1 to 5 model papers is already done. 6 to 7 is also done as a different video. You guys can watch that. Now in this one, I'm going to do 8 to 10. So if you have not watched it already, please go and watch it. Okay, so in this case, people, what is happening? This is nothing but Sale of Goods Act, ascertainment of a price. So the price can be fixed by the parties or it can be fixed by a third party. Now, if at all the third party is unable to fix the price, then the contract can be avoided. So in the given case, people, because if at all the transfer of possession has happened, if we have already transferred the property from one person to another person, if the transfer has happened, then remember people, the buyer will have to pay the seller reasonable price if at all the price was unable to be ascertained. So in the given case, because the product is already transferred, they have already transferred the product. Now because of that, what will happen people? You will have to pay whatever is reasonable price because transfer has happened. Now they're asking, will your answer be different if Priya had not handed over the vehicle to Sony? Yes, if Priya had not handed over the vehicle to Sony, my answer will be the contract can be avoided because the transfer has not taken place yet and the third party was unable to derive the price. Clear? Simple. Define OPC, direct. Okay. PQ and R formed a partnership agreement to operate motor bus along specific routes for a duration of 12 years. After operating the business for 4 years, it was observed that the business incurred losses each year. Despite this, P is determined to continue the business for the remaining period. Examine with reference to the Indian Partnership Act, can P insist to continue the business? If so, what options are available to Q and R who are reluctant to continue the operating of business? What is this people? This will come under first one, can P insist? Answer is yes, you can insist. You don't have, it's not wrong or right. You can insist. Yes, you can insist. Answer to the second question, what is a provision of the law? This comes under people, dissolution by the order of the court. What are the rights does the Q and R have? Remember people, this is nothing but perpetual losses. The company, the partnership firm is having losses for every year. They have a right, they can go to the court, they can submit their application. If the court thinks that it is right to shut down, the court will order for winding up. But remember, it all depends upon the order of the court. My provision is dissolution of the partnership firm by the order of the court. What is the ground? The ground is perpetual losses. That's what is the option available to Q and R. See, very good, very good. For those of you who answered it, very, very good. Keep it up. Next one. See, that's how you guys need to do. Pause it. Write down these 3-4 words. If you guys have it in your answer, trust me, 70 is on the bank. Underline it. And you guys might be tense, sir, what if I'm not able to remember the section? That's why even I'm not stressing the section. Leave it. Remember, in many places, prospectus of ICAI, textbooks of ICAI, they have clearly given, if at all the student is unable to write the section, we will not deduct any mark. So it's okay. You guys just have to identify a right provision. That's what you guys have to do. That's achievable, right? Okay. A and B operate a textile merchant business in partnership. Mr. A finances the business and is a sleeping partner. In the regular course of business, B acquires certain fabric goods belonging to C. However, B is aware that these goods are stolen property. Despite this knowledge, B proceeds to purchase and sell some of these stolen goods. Moreover, B records proceeds from these sales in the firm's books. Now, A wants to avoid the liability towards C on the grounds of misconduct by B. In the light of the provision of Indian Partnership Act, discuss the liability of A and B towards C. Remember people, whatever is the, any act done by a partner because of mutual agency, it binds all the other partners as well. Even if it's a misappropriation, it binds the other partner. Even if you are a sleeping partner, it binds the other partner. In the given case, it's a misappropriation, or it can be considered as misconduct. Misconduct by B in the course of the business will bind A. Even though he is a sleeping partner, it will bind A. So in the given case, A and B both will be liable to C. Now they can ask you what rights does A have, which they have not asked you here. Remember, because B did all of this people, B is liable to indemnify the firm. That is his duty. That they have not asked it, but they can ask you. It is a duty of the partner who has done a fraud, misconduct. It is your duty to indemnify the firm, which they have not asked, but which can be very well asked. Good. For those of you who are getting it, very nice. This question we have seen multiple times. XYZ is a company incorporated under Companies Act. The paid up share capital of the company is held by others like this. So in XYZ company, the shareholding is like this. Central government has held 20%, LIC 8, Government of Tamil Nadu 10, Rajasthan 10, ABC Limited 15. Now in this case they are asking you, is XYZ a government company? No people, it is not a government company. The reason is because you just need to take what is a government company. Wherever not less than 51% of the paid up share capital having total voting power, 51%, at least 51% is held by central government, state government, state governments. Correct? Only that is what is there in the definition. All of this is not there in definition. No, where is it there? So I will only add this 20 plus 10, 30, 30 plus 10, 40. So sir, only 40% is held by the government, and hence sir, it is not a government company. Remember, you are not supposed to add this LIC and this and all. Hello? Only thing, another thing they have given is, if there is a government company's subsidiary company will become government company. To become subsidiary, you should hold 51%, meaning more than one half. I would say 50.1. Yes. So in the case, this and all, nowhere in no definition they have added that you can add 8%, 5% and all. Then we are not supposed to add. Most of the students will add it. Remember, it's wrong. In the given case, XYZ is not a government company. M and N holding 70 and 30% of shares in company. Both died in an accident. Answer with reference to the provision of Companies Act. What will be the legal effect on the company as both the members have died? People, perpetual succession. The company will continue to carry on the business. The legal heirs or the nominees will step in their shoes and they will become the next members. Correct? Direct question. Okay. Mr. J entered into an agreement with Mr. S to purchase his house for 20 lakh within 3 months. He also paid rupees 50,000 as token money. In the meanwhile, in an anti-encroachment drive of the local administration, Mr. S's house was demolished. When Mr. J was informed about the incident, he asked for the refund of token money. Referring to the relevant provision of Indian Contract Act, state whether Mr. J is entitled to the refund of the amount paid. Yes, people, you are entitled to the refund of amount paid because the contract has become void. It's a void contract. Impossibility of performance due to destruction of subject matter. So any benefit taken under voidable contract, it is your duty to return the entire benefit taken. All these words has to be there in my answer. Void contract, destruction of some subject matter, supervening impossibility, subsequent impossibility, and whatever I told you, voidable contract, any benefit taken must be returned. That's my answer. So if all of this is there, yes, see, you'll get, see, if you're able to go to that extent, then people, trust me, crazy. Next one. Rama directs Sham to sell laptops for him and agrees to give Sham 11% commission on the sale price. fixed by Rama for each laptop. As Government of India put restrictions on import of laptops, Rama thought that the prices of laptops might go up in near future, and he revokes Sham's authority for any further sale. Sham, before receiving the letter at his end, sold 5 laptops at the fixed price by Rama. Sham asked for 11% commission on the sale of 5 laptops for rupees 1 lakh each. Explain under the provision of Indian Contract Act whether sale of laptops after revoking Sham's authority is binding on Rama. Whether Sham will be able to recover his commission from Rama. If yes, what will be the amount of such commission? We already seen this. Revocation of agency. When will it be effective, people? Not from the day you wrote the letter, but from the day the agent gets to know about it. Knowledge. That means what? Whenever he reads the letter you have written, that is when the agency gets revoked. In the given case, you have written it correct, but before he read it, he has already made a sale, because of which the sale made by an agent will be binding on the principal. So in the given case, whether sale of laptops after Sham's authority is binding, answer is yes, it is still binding. Second one, what is the commission you will get? 11% on each laptop of 1 lakh. That means what? 11k per laptop into, he has sold 5 laptops. So 11 into 5, 55,000 is the commission that he will be entitled to. Simple, wonderful. Okay. Direct question. Okay. Ram sells 200 bales of cloth to Sham and sends 100 bales by lorry and 100 bales by railway. Sham receives delivery of 100 bales sent by lorry, but before he receives the delivery of the bales sent by railway, he becomes bankrupt. Ram, being still unpaid, stops the goods in transit. The official receiver on Sham's insolvency claims the goods. Decide the case. Now, people, what is the case, people? We all know it is coming from Unit 4, unpaid seller. Because the whole of the price is not paid, I become a unpaid seller. So, remember, in the given case, when part of the quantity is delivered, I can stop the other part of the quantity which is still in transit. So, in the given case, Ram can still stop the goods which are still in transit. The 100 bales he can stop because those goods are still in transit. Simple. Classify the following transaction according to the type of goods they are. A wholesaler of cotton has 100 bales in his godown. He agrees to sell 50 bales and these bales were selected and set aside. What is this, people? 100. Out of that 100, we have selected and kept aside 50 bales. That means what? They are ascertained goods because from the bulk they have been separated. From 100 they have been separated. So they are ascertained goods. Next one, A agrees to sell B 1 packet of sugar out of the lot of 100 packets lying in a shop. So he agrees to sell. It is not yet separated. So it becomes what? Unascertained goods. Third one, T agrees to sell, yes, all the apples which will be produced, which is not yet produced. So what will I consider it as? I will consider them as, people, future goods. Very good for those of you who got it. The last one, sir, referring to the provision of Negotiable Instruments Act 1881. Answer the following. What does it say? Aman drew the bill of exchange on Baban, who accepted it payable to Magan. So Magan will become the payee. Magan endorsed the bill to Gagan. Gagan endorsed the bill to Akash. What is this done? Bill to Akash to be delivered to him on the next day. However, on death of Gagan, on the same day, his only son Ankit delivered the bill to Akash on the next day as intended to his by deceased father. On presenting the bill on the due date, Baban refused to pay. Explain the importance of delivery negotiation. Decide whether Akash can enforce the payment of the bill against Baban or the previous parties. Now, what is that, people? Now, Gagan had written a bill But before the bill was endorsed, Gagan passed away. He passed away. So what happened? His legal representative, his son, he just took that bill and came and gave it to Akash. They're asking you, is this a valid endorsement? Remember, people, whenever a party passes away, you cannot just merely transfer the bill. You do not have a right. So if the bill is still undelivered, people, so a negotiation cannot happen, a transfer cannot happen. So in the given case, Akash cannot claim any money. You cannot transfer. Understood? Yes, sir. Remember. Okay, next one, Reliable Limited, an Indian company, is a global leader in petrochemical products. For payment of the sale price of machinery imported from Alex Manufacturing Limited, a USA based company, the Indian company drew a bill of exchange on Manish, a resident of Mumbai, who accepted the bill at Mumbai payable to the exporter in Los Angeles, USA. Decide whether the bill of exchange is an inland or a foreign instrument. Assume that the bill of exchange was signed by the authorized person for the drawer company. Now, what are that, people? The Indian company drew a bill of exchange. That means what, sir? Indian company. So where was the bill drawn? Bill was drawn in India. Now what is the next condition to be satisfied? If the bill itself was not drawn in India, it becomes a foreign instrument. Now because the bill was drawn in India, it becomes a inland instrument. Provided there should be one more condition to be satisfied. What is that? Drawee resides in India or the bill is payable in India. So in our case, we will see what else is satisfied. Bill of exchange on Manish, a resident of Mumbai. So drawee is in India. So two conditions satisfied. Hence this becomes a inland instrument. Simple. Okay. Okay, the last question. J, a wholesaler of premium basmati rice, delivered on approval 100 bags of rice of 10 kg to a local retailer on sale or returnable basis within a month of delivery. The next day, the retailer sold 5 bags of rice to a regular customer K. A week later, K informed the retailer that the quality of rice was not as per the price. The retailer now wants to return all the rice bags to J, including the 4 bags not used by K. Can the retailer do so? Also discuss the provision. Now, what is that, people? A wholesaler has given 100 bags to retailer. Retailer has further given customer some bags. I have given 100 bags. He has sold 5 bags to the customer. The customer said, whatever you have promised, the product is not as per the quantity. So he has returned the 4 bags back. Now they're asking you, how many bags can R return? Is it because 1 bag is already used that I cannot return? What else I can return? 1 is out of 100 because this fellow has returned only 4. I have 95 with me plus I got back 4. So the question is, can I return all the 99? Is it possible? Remember, in sale or return basis, whenever you're accepting or whenever you're keeping the product beyond the duration fixed, or whenever you do something equivalent to an acceptance, it will be considered as if people, the acceptance was communicated, acceptance was made. So in the given case, people, when you further sold 5 bags, that means the ownership for the 5 bags are transferred from W to R. It is transferred. Now you cannot do anything. So people, in the given case, what happens? I can return only 95. The rest of the 4 I cannot return because the ownership for it is already transferred. It is your duty to check when you gave the product. Yes or no? That is the answer. Simple. Very, very simple. No and go. Okay, the next one. R owns an electronics store. P is, so we are looking at the model paper number 9. R owns an electronics store. P visited the store to buy a water purifier priced at 54,000. He specifically requested R for a purifier with a copper filter. As P wanted to buy the purifier on credit with the intention of paying 9 equal monthly installments, R demands a guarantor for the transaction. S came forward and gave the guarantee for the payment of water purifier. R sold P a water purifier of a specific brand. P made payment for 4 monthly installments and after that became insolvent. Explain with reference to the Indian Contract Act the liability of S as a guarantor to pay the balance price. Yes, people, you are liable. So remember always, the liability of the surety is always secondary in nature. If at all the debtor does not pay, it is my duty to repay. In the given case, out of 9, he has already paid 4. Then rest of the 5 installments I need to pay. So the total price of the cost was how much? 54,000. 54 divided by 9 is how much? 6,000. So per month I need to pay 6,000. Total outstanding is how much? Another 5 months I need to pay. So I need to pay 30,000 rupees. Clear? What will be your answer if R sold the water purifier misrepresenting it as having a copper filter while it actually has a normal filter? Remember people, surety is discharged if at all there is any if at all there is any misrepresentation or concealment of a fact. So people, the principal debtor is also discharged, surety is also discharged. Simple, that's my provision. See, simple, clear? A company ABC Limited as on 31st March 2023 had a paid up capital of 1 lakh, which is 10,000 shares each. In June 23, ABC Limited had issued additional 10,000 shares. So they have added another 10,000 shares. Equity shares, which was fully subscribed. Out of 10,000 shares, 5,000 of these shares were issued to XYZ. So XYZ is holding 5,000 shares. Of these shares issued to XYZ. XYZ is a holding company of PQR Limited by having control over the composition of its board. So this is a holding company of PQR Limited also, it seems. Now PQR Private Limited claims the status of being a subsidiary of ABC Limited. Is PQR a subsidiary of ABC Limited? That's a question. That is XYZ Private Limited. Examine the validity of the claim of PQR Private Limited. No people, nowhere related, not even one share is held. So PQR Limited is not a subsidiary of ABC or XY, subsidiary of ABC? No, they are not subsidiary of ABC. State the relationship, if any, between ABC and XYZ. ABC and XYZ, what is the relation? The total shareholding is 20,000 share. In that 5,000 shares is held by XYZ. That means how much people? 25%. That means what? ABC is an associate company of XYZ. Section 2, clause 6. Significant influence. Hello. The next one, the Indian Partnership Act does not make the registration of firms compulsory. Yet the consequence, we know, direct question. Consequences of non-registration. Cannot claim set off, cannot file a suit on third party, but you can file a criminal case as the case may be. Sony, a friend of Priya, wanted to buy her two-wheeler, which we just now saw in the 8th paper. Ram wants to incorporate a company in which he will be the only member. They are asking about OPC. LLP, see same things which you already seen. PQR formed a partnership to operate motor buses. Same thing. Oh, it's repeating the. ABC operate textile. People, same thing. The sleeping partner of C. A and B will be liable. Ho 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 ho. Hauser. Same thing. The. Laptop, I think this entire thing is repeated, people. Okay, this is new. PTC hotels in Bombay decided to sell their furniture by auction sale. For this purpose, they appointed RN and Associates as auctioneer. They invited top 10 renowned architects in Bombay for bidding. A right to bid was not notified by them. Furniture was put up in lots for sale. It was decided that for every lot of furniture, there will be a base price. on 25th February 2024, auction sale was started at 10 a.m. in the lawn of PTC Hotels. For a special lot of furniture, 3 parties came for bidding: Neil, Raj, Dev, and their bidding amounts was as under. The sale was completed in favor of Mr. Neil by R.N. Associates by fall of hammer. They gave it to Neil. Mr. Dev's bid was rejected on the ground that the right to bid was reserved and the company of Mr. Dev was not invited to the bid. For another bid of Italian furniture, the bid was Dheer and Madhu. Madhu has bidded on behalf of R.N. and Associates. The sale was completed in favor of Mr. Dheer instead of Mr. Madhu. Mr. Dev and Mr. Madhu argued that the auction sale was not lawful. Give your opinion with reference to the provision of Sale of Goods Act. Remember people, auction sale. If you ask me, it's a little tricky question. In our direct provision, it will not be there, but in our class, we would have explained this also. What is that? Remember people, in auction sale, there are 2 types of auction. One is called as a close auction, one is called as an open auction. If it is a close auction, people, only those people who are invited can bid. If it's an open auction, anyone can bid. Sir, how will we know whether it is a closed auction or an open auction? It will be given in the auction invitation itself. If they have given it as the right to bid is notified, that means only those people who are invited can bid. If the right to bid is not notified, anyone can come and bid. In the given case, is the right to bid notified? Answer is no. It is clearly given. A right to bid was not notified. So, when 3 people came, they rejected Dev's bid saying that you were not invited for the bid. Remember people, they cannot reject it. This is a valid sale. Hello? So, it is unlawful. In the given case, Madhu on behalf of R.N. and Associates. Remember people, whenever any person is representing a seller, whenever anyone is representing a seller, then remember people, in such scenarios, you have to always write, you should reserve your bid. In the given case, they have not given anything on whether the bid was reserved or not. We will assume that the right to bid was not reserved. Because you are representing a seller, because you are conducting an auction and someone from your company only has represented the bid, which is not possible, right? Hello? So that was lawful. The first one was unlawful. You shouldn't have rejected the bid. That's my answer. Auction sale. Clear? Easiest one. Mr. Y issued a check for 10,000 to Mr. Z, which was dishonored by the bank because Y did not have enough funds in his account and has no authority to overdraw. Examine as per negotiable instrument. Mr. Y is liable for dishonor of check. If yes, what are the consequences? Yes, people, it is a dishonor of check. Consequences, people, you will have to repay the money. If not, people, you can be imprisonment up to 2 years, fine up to 2 times of the value of the check. Hello? That can be the fine. What would be your answer if Y issued a check as a donation? Then no, people, you cannot recover because the check bounce case will not come in the case of gift, donation or security. It only comes in the case of debt. It should be a legally enforceable debt. If it's a free of cost, you do not have a right of dishonor. That is, check bounce case will not attract. Done. J, a wholesaler, premium kg, same thing. Done. Okay, the last paper. Okay, Mr. L let out his residential electricity. Okay, people, we already seen payment made by a interested person. Same thing, it's repeating. So we already covered. Next one, Mr. A offered to sell 25 chairs to Mr. B at 1,500 rupees per chair on 12th Feb 24. A promised B that he would keep the offer open till 15th Feb. However, on 13th Feb, he sold those chairs to Mr. C at 1,700 rupees per chair without the knowledge of B. Mr. B communicated the acceptance of the above offer on 14th Feb. Advice with reference to the provision of Indian Contract Act whether B can claim damages from A. Remember people, if you keep the offer open for 3 to 4 days, we generally call it as what? Standing offer or a continuing offer. However, if the acceptance is not made, a offer can be revoked at any given point of time. Even though I said I'll keep it open for 3 days, I can revoke it at any given point of time. In the given case, acceptance is not made yet, and hence I can revoke it and the revocation is valid and B cannot claim any damages from A. That's my answer. Revocation can be done. Mr. A was running an orphanage, which you already saw. Philanthropist, this is nothing but charity. Same things are repeating. Okay, Kamal, a chartered accountant, started his e-commerce business by incorporating a OPC on 1st October, he being a sole member. People, for this understanding of OPC people, there is one video that I have uploaded on YouTube. I strongly recommend all of you to watch this with regards to OPC. Yeah, and also I have done one latest edition of something called as must solve questions. There is OPC or OPC resident or otherwise. Just type OPC resident or otherwise. See, one person comes here. Watch this, people. In that I have taken up that question. Very important. Watch it and go. It is just 20 minutes. Watch it, much needed. Is this clear, all of you? Okay, in that I have taken up this question. Please watch it because there is some logical reasoning behind it. Okay, next one. XYZ Limited was incorporated to hold the patent which we saw 1 crore rupees significant accounting transaction. Same things are coming again and again. Measures RK Traders made a contact with Measures CK Traders for purchase of 2000 kg of basmati rice specifically grown in Chhattisgarh state. Should be packed in pink color bags of 25 kg each to identify the place of origin by specifying the mode of packing of basmati rice. The seller agreed for specific packing of rice grown in Chhattisgarh state. However, by misunderstanding, the staff of seller packed the quantity of 1800 kg of basmati rice grown in the state of Maharashtra in white color bags of 30 kg each and the remaining quantity of 200 kg grown in Chhattisgarh state in pink color bags of 25 kg each. Referring to the provision of Sale of Goods Act, analyze whether the buyer has the right to reject the entire quantity of basmati rice supplied by the seller. On the other hand, what is the remedy available to the buyer if he has to accept the entire quantity to fulfill his other contracts? So in this case, people, of course, I have a clear description. I'm clearly asking Chhattisgarh. If you have given me some other state, I think he has given which state? Punjab. Allah. 1800 kg grown in Maharashtra. So my order itself is 2000 kg. 1800 kg they have given me Maharashtra. And remaining 200 kg grown in Chhattisgarh state in pink color bags of 25 kg each. So people, now in this case what happens? Whenever the goods can be separated, people. So I have a right, what? To reject the whole goods, or I can keep the 200 and I can reject the 1800 kgs as well, or I have a right to reject the whole of the quantity as well. So in the given case, yes, I can reject it. I have a right. Next one, what are the rights I have? Any damages I suffer, people, I have a right to recover that money from you. Treating breach of warranty. Imagine if I accept this entire 2000 kgs to fulfill my obligations. I have a right to claim this compensation from you. Breach of warranty. I can claim compensation. Treating breach of condition as breach of warranty. I can claim compensation from you. That is the right I have. Simple. Okay, Karthik agreed to sell his laptop to Vasant. Okay, Karthik agreed to sell his laptop to Vasant for a price fixed by Kusuma hardware engineer. Same thing, people, whatever the two-wheeler case we saw, a third party is doing a valuation. If the product is delivered, I need to pay reasonable price. If the product is not delivered, then you can avoid the contract, meaning you can cancel the contract. Sir, what if one of the parties only preventing the third party from carrying on the valuation? What if one of the parties itself is stopping other party from carrying the valuation? Then people, you can again treat the contract as void, and you can also claim compensation for stopping a party from doing the valuation. I can stop. That's the answer. That's what it's repeating. Okay. Ram and Shyam are partners in a partnership firm styled as RS & Co. Gopal, a renowned businessman, is their common friend. Ram introduced Gopal to Sundar, a supplier to the firm, as his newly joined partner. So people, there are two partners, but Gopal is a friend of them. They've introduced Gopal as a partner. This is what? This is called partnership by estoppel or partnership by holding out. So in such case, what will happen? I will be liable for that party. Any profits or any liabilities for both, Gopal will be liable. Correct? Gopal, knowing that he is not a partner, preferred to be quiet. On such an introduction, this information about Gopal being a partner of the firm was shared by Sundar with another businessman, Madhav. So the question will be whether is Gopal liable to all the contracts entered between Sundar and Madhav? For Sundar, yes. For Madhav, no. Because I am liable only for those parties with whom I also was present and I kept quiet. In the given case, I was not present at all. Sundar said to Madhav, for that I will not be considered liable. So Sundar, yes. Madhav, no. Simple, yes. Partnership by holding out. On admission as a new partner, Amar agreed to be liable for the existing debts of the firm by an agreement signed by all the partners, including Amar. Examine whether Amar will be liable in a suit filed by the creditor. Remember, people, for the new partner to be liable, it has to undergo a process called as novation. All the old partners plus the new partner, a partner coming in, plus the creditor, all of them have to agree, people, for the new partner to be liable for the old debts. In the given case, the consent by the creditor is silent. So people, until the creditor pays, until the creditor agrees also, people, you will not be liable. In the given case, the question is silent. So we assume that the creditor has not given his consent, and hence the new partner cannot be held liable by the creditor. Clear? Yes. Okay. Suman, having 10% share in the property of 200 lakhs of a firm, yes, 10% share, retires from the firm. The firm continues with the business thereafter without final settlement of accounts between the existing and the retired partners, and earned profits of 10 lakh during the financial year. They have earned 10 lakh. Suman, in her own interest and in the absence of any provision in the partnership firm on this point, claimed rupees 3 lakh from the firm towards the use of her share in the property and profit of the firm, which was rejected by the partners. There is no contract between the partners contrary to the provision of the Act. Examine the validity of the amount claimed by Suman under the provision of Indian Partnership Act. Clear? That is what they have given. How long they have done? Okay, so people, see here. See, whenever a partner leaves the firm, in such case, what is the money I can claim, people? Whatever is my share of profits. My share is how much? They have made 10 lakh. Agreed? That's what it is. Yeah, let us assume that my share is people. They have not said how many partners are there. So let us imagine my share will be 10% of the profits. That will be around people. 1 lakh rupees is my profit. Or how much can I claim? I can claim 6% on my total share in the profit firm, in the partnership firm. So how much is my share? Out of 200 lakh, my share is 10%. That is how much? 20 lakh. So 20 lakh, how much interest can I claim? I can claim up to 6% interest per annum. So 20 lakh into 2, 1.2. So I can claim people 1 lakh or 1.2 lakh. I can either claim 1 or 1.2 lakh. In the given case, how much is she claiming? 3 lakh. 3 lakh is invalid. So I can either claim my share of profits or I can claim 6% on my total asset. So it is either this or that. I cannot claim people 3 lakh. 3 lakh is way beyond what I am entitled for. So 3 lakh you will not be entitled. Simple. Okay, next one. JV Limited borrowed a secured loan of 5 crore from Star Bank Limited. JV borrowed from Star Bank to meet its working capital requirement. However, the borrowing powers of the company under its MOA were restricted to rupees 1 crore. The maximum they could borrow was people rupees 1 crore it seems. By MOA. The bank released the loan amount in 2 installments. So they have given 1 plus 4 crore. They have given 5 crores. On the due date for repayment of the loan, the company refused to accept the liability of 5 crore on the ground that the borrowing was ultra vires the company. The company's books of accounts show that the company has utilized the loan amount of 3 crore for repayment of lawful debts. The utilization of the remaining of 2 crore cannot be traced. Referring to the doctrine of ultra vires, examine the validity of the decision of the company denying the repayment. Remember people, because it is clearly given in my MOA people under doctrine of constructive notice, the company is not liable for anything which is not given in its MOA. So in the given case, yes people, 1 crore is intra vires, rest of the 4 crore is ultra vires. So how much has the bank given? Bank has given 5 crore. So technically the company is liable for 1 crore and the company is not liable for 4 crore. However, there is one catch here. What? People, it is an ultra vires. But why did you use this 3 crore rupees to repay your other debts? If you think you guys could not buy it, you could not take it, then you should have repaid. What did you do? You used this money to repay someone else's debt. So now this bank will be given the same right as the other creditor. I will have a right to recover this 3 crore. So out of this 5 crore people, 3 crore I can recover. 2 crore we are not able to trace it. So the company is not liable. Ultra vires transaction. The contract will not bind the company. Clear? Okay, next one. After incorporation of Goodwill Private Limited on 2024, the share certificates were issued to Amit, Sumit and Sumati being the subscribers to MOA without affixing the common seal. Under the signature of Amit and Sumit, the directors of the company. The company has yet to appoint a company secretary. On objection raised by Sumati, a director, about the validity of the share certificate signed by other 2 directors, Amit and Sumit clarified that since the company has opted not to have common seal for the company, the share certificate signed by 2 directors are valid. Is it valid? Remember people, if a company does not have a common seal, if common seal is not there, then if you have a company secretary, then the company has to get the signature from 1 company secretary and 1 director. What if a company does not have a company secretary? Then your certificate has to be signed by 2 directors. In the given case, as the company does not have common seal, neither a company secretary, the signature done by 2 directors is valid. However, would your answer be different if company had a company secretary? Yes, my answer will be different. In such case, my share certificates shall be signed by 1 CS and 1 director. Simple, very easy, clear. Next one, Raghav found gold and diamond studded wrist watch value approximately 1 lakh on the roadside. He picked it up and then advertised in the newspaper that the true owner thereof can take watch after showing the proper evidence. After waiting for a certain period of time, when the true owner did not turn up, he gifted the wristwatch to his son Mahesh. A few days later, Madhav, the true owner of the watch, somehow noticed his watch on the wrist of Mahesh. He approached him to collect the same, but Mahesh refused. In the evening, Raghav called Madhav and told him that he incurred 20,000 to find the true owner. If he fails to reimburse him the lawful expenses incurred on finding out the true owner, he will sue him for recovery thereof or retain the possession of the watch with him till recovery. Even he can sell the watch for recovery of expenses. Advise Raghav were lawful according to the provision of Indian Contract Act. Gifting the wristwatch to his son. Can you gift people? Remember, this is nothing but finder of lost goods. Remember people, you can only retain the goods. You cannot sell the goods until the goods are perishable, or you could not find the true owner even after a reasonable search, and the expenses in finding the true owner is coming to 2/3 of the value of the product. Here people have incurred 20,000, but the value of the product is 1 lakh, which is definitely less than 2/3 is what we have incurred. In such case, whoever finds it, you can just keep the goods with you. You do not have a right to sell. So people gifting here was not valid. Remember that. Very, very important. Warning Madhav to sue for recovery of lawful expenses incurred in finding the true owner. Remember people, you do not have a right to sue because it was voluntary expenses. You cannot file a case to recover that money. No, you can only retain the goods. Third one, retaining the possession of wristwatch till the recovery of lawful expenses are paid is valid. You have a right. Fourth one, selling of wristwatch for recovery of expenses. No, you cannot sell because the value is not coming to 2/3. Neither it is perishable goods. So you do not have a right to sell. Only option with you is you can retain the product. Next one. Woolen Garments Limited entered into a contract with group of women in July 2023 to supply various woolen clothes for men, women and kids like sweaters, monkey caps, mufflers, etc. before the commencement of the winter season. The agreement expressly provides that the woolen clothes shall be supplied by the end of October 2023 before starting of winter season. However, due to prolonged strike, women group could tender the supplies in March 2024 when the winter season was almost over. Analyzing the situation and answer the following. What? Whether the company can reject the total supply? Yes. Why people? Remember, is it a impossibility of performance? Answer is no. Strike is not impossible people. It is just difficulty. You can bring someone else and make them work, or you can go and negotiate with your own workers and you can still make them work. Remember, strike is not impossible. Strike is just a difficulty of performance. So that is not a valid ground to consider your contract as void. Clear? Next one, whether company can accept the total supply on request of women group. You can accept it, people. That is, it is optional. It's voidable. But can I cancel it? Answer is yes, I can cancel the entire thing because people, time is essential. When a time is essential for a contractor, if the goods is not supplied in that time, then I have a right to rescind the contract. Means what? I have a right to cancel the contract and claim compensation. Hello? Yes, I have a right. Done. Next one. Ashoka trader delivered a camera to Mangesh on sale or return basis. Same thing, sale or return basis. We saw. Yeah. Okay. See, Ashoka trader delivered a camera to Mangesh. Mangesh delivers the camera to Rahul on the terms that sale for cash only or return. Afterwards, Rahul delivered it to Vishal on a sale or return basis without paying cash to Mangesh. So Rahul has not paid money to Mangesh. The camera which was in the possession of Vishal was lost by theft, though he exercised due care for its safety. Referring to the provision of the Sale of Goods Act, analyze the situation and advise whether Mangesh, Rahul or Vishal are jointly or severally liable to pay the price for the camera. Remember people, sale or return basis. We had given it to Mangesh. When Mangesh further sold it, people, ownership is transferred. So Ashok is definitely not liable. Correct? Okay. Next, Mangesh gave it to Rahul on a condition. What is that? Sale for cash only or return basis. So here I am telling you it has to be. You have to pay. If not, I will not give you the ownership. It is like reservation of right of disposal. But Rahul, without giving the cash, he has further sold it to Mr. Vishal. That means what? I have not paid cash. That means what? Reservation of right of disposal. Ownership is not given to Rahul at all. And Rahul gave it to Vishal. Of course, Vishal also did not get a title. And Vishal was not negligent. He took a due care. He was not negligent. So Vishal not liable, Rahul not liable because cash is not paid. The ultimate liability will be on Mangesh. Mangesh has to pay it to Ashok. That's the answer. Tricky one, no? Good. Ansari of Jaipur sold 100 smart TV set for 50,000 per set to Baburam of Delhi. He delivered the TV sets to Chetan, a transport carrier, for transmission to Baburam. Baburam further sold these 100 TV sets to Shamlal at 60,000 rupees per set. On reaching the goods at the destination, Baburam demanded the delivery, but Chetan wrongfully refused to deliver the goods. People, when does transit come to an end? Whenever the carrier wrongfully refuses to deliver the goods, transit has come to an end. That is why he failed to deliver TV sets to Shamlal and suffered a huge loss on account of non-delivery. Ansari came to know about this. He directed Chetan to stop the delivery to Baburam and re-deliver the goods to Jaipur. Whether Ansari has a right to stop the goods in transit? No, because wrongfully refused to deliver, transit has come to an end and hence you cannot stop the goods in transit. Whether Baburam can claim losses suffered? Answer is yes, Baburam can claim losses suffered from Ansari. Okay, next one. Negotiable. Aman drew a bill. This is what we have seen in our previous paper only. Reliable Limited Indian company. This also we saw. Inland bill. 8th paper. Rest all is direct. That's all. So that's your 3 papers. That's like within an hour, people. Come on, people. Around 30-40 questions in an hour. And you get to know so many provisions. I feel you guys should put more effort. Yeah. Remember, after this, I'll also put a combined merged version of all the 10 model test papers. Watch it out. And remember, people, I'm also coming up with a video. I'm thinking of doing a video which just have difference between provision from one to another, and that file will have, that video will have only difference between. If you guys want it, do let me know in the comments. I'll definitely work on that as my next video. And I've already recorded a complete series on case law, 100% case laws covered within 2 hours. And I've also given you the whole file free of cost. It is a free to download PDF. Make use of it. So, and you let me know what more you guys want. And I'll try my best to put out there. Yeah. So wish you guys all the best. Do well for your exams. See you. Bye-bye.